Okay, we're about to get started. First off, I would like to welcome everyone for joining us this evening. My name is Natalie Nahas, the Senior Business Development Officer with the Los Angeles Police Federal Credit Union. And tonight, you guys are here with us for our estate planning webinar. So, tonight, we'll walk you through the estate planning process, and we'll talk to you about the steps that it takes to help you secure your loved one's future. You'll learn about Trust and Will, an online service that's available to our members, and it's basically an easy and quickly creatable will and trust with expert help along the way. So just make sure that you stay tuned because we are giving away a free Trust and Will package from our Trust and Will partner valued at $600. So everyone who's registered for the webinar tonight must watch it in live mode, and we will select a winner tomorrow. They'll be notified. So stay tuned. Just make sure that you watch the duration of the webinar. Also, as a special incentive, Trust and Will, our partner group, is offering a 25% discount on an estate plan for National Estate Planning Week. And that's offered from October 16th to 31st. And it's a really good deal because normally the discount's at about 10% off. So 25% off is a really good, way to get started. So before we do kick off tonight, I would like to mention that this session is a live webinar and a recording will be sent out after. And that you will be in listen-only mode. So we will have some dedicated time towards the end of the presentation to go over questions and answers. So we encourage you guys to put the questions in the chat in the Q&A feature, and just make sure you send it to all, so then that way we can all see it. So now, without further ado, I'd like to turn it over to David. David is our partner associate from Trust and Will. Thank you, David.
Great. Well, thank you so much, Natalie, and thank you all for joining today. So as mentioned, I'm David. I lead partnerships here at Trust and Will, and I will be your host today for our Estate Planning 101 webinar. So I should also add, I'm joined by Jason Young from our member support team, who's manning the Q&A box today. So as we go through the presentation, if you have any questions, please use the Q&A box to enter them in, and Jason will answer your questions as they come through. And then at the end, after the presentation, which should take 30 minutes or so, I'm going to actually speak to some of the top questions, and we'll go through the top questions and answers to help provide additional information for each of you. So again, as I'm talking, feel free to send some questions to Jason through Q&A, but hopefully I'm able to answer a lot of your questions throughout the presentation. So today we'll be discussing the basics of estate planning. We'll start by defining why an estate plan matters and what an estate plan is, and also what it does. Then we'll cover some of the key documents in an estate plan and how to decide which documents are actually the best documents for you. Finally, we'll conclude with who needs an estate plan, some of the most common reasons it might be time to actually create an estate plan or update your plan, and how to get started in creating your estate planning to secure your legacy. So again, questions along the way, feel free to reach out via Q&A, and with that, we will get started. So to set the stage on how important this topic is, it's important to know that estate planning can actually help plan for what is the largest personal transaction of most people's lives. And so that said, typically it's also the piece of financial well-being that's actually least prepared for by most American adults, unfortunately. And so without a plan, most people end up leaving their assets and their legacies subject to probate, which basically means the government will make those decisions on your behalf. And so we'll talk about all of that in the future, but just wanted to set the stage on how important this concept of estate planning is, and to thank you again for joining to learn a little bit more. So unfortunately, nearly 2/3 of American adults procrastinate and actually don't create an estate plan until it's too late. This is we're on the next slide now. So the three primary reasons for not having an estate plan are one, lack of education. So, what are the risks of not having an estate plan set up? Uh, that's something that we'll certainly talk about today. Another is the cost. So traditionally, you'd have to go directly to an estate planning attorney. Can cost anywhere between $800 to $1,000 for a basic will, three or four, maybe $5,000 for a basic trust, and that can get very, very costly, right, for the average, or really for anybody. Um, and then finally is accessibility. So who do I trust? What lawyer do I know? Should I go to? Who's going to do it right? These are the questions around accessibility that we actually hope to solve, which we'll talk about later in our offering at Trust and Will. So with this, I will say that, as mentioned by Natalie earlier, LAPFCU is partnered with Trust and Will to help you through these hurdles. And so we'll talk about estate planning in general, and then at the end we'll talk about Trust and Will, which is our product, and how you can utilize us. So what is estate planning? Estate planning is planning today for what might happen tomorrow. And so at the most basic level, an estate plan lets you make the decisions again today about what should happen if you're unable to make decisions in the future. It's a set of instructions that specifies what might happen to your assets, or what you want to happen to your assets, what you want to happen to your belongings, your physical body, and so on. And so it's a really important piece of planning, really, for anybody. Um, so why should someone care about estate planning? So on the next slide, we'll see what should motivate someone, right, to actually create their plan. Well, there's a variety of reasons. I mean, first and foremost, at least for me, is peace of mind. Like once it's done, when I completed mine about a year ago after having my first son, and the peace, I can't really speak to the peace of mind that it gave me and my wife, for just, okay, knowing that my wishes are out there and covered, ready to go if anything were to happen. And so it's this peace of mind that's like, whew, once you're done with creating your plan. You're also able, and as part of this, is to name your legal guardians to care for your minor children and pets. So, someone like me, if you have a minor child, or children or pets that you care about, you want to nominate your guardian so that who's going to care for them, if upon passing. Another important reason is to prepare for potential incapacity during your lifetime. So this is a key piece that a lot of folks don't realize, is that estate planning is not just it doesn't just go into effect after passing. It's actually something that's important to create in order to help prepare for incapacity during your lifetime. What happens, if you were incapacitated, who makes those medical decisions for you, who has the power of attorney, and so on. Those are all parts of the estate plan, which we'll talk about today. And then I think that one of the last things I'd say is that, if you don't have an estate plan in place, as we've kind of mentioned before, um, you're really leaving it up to the government to make those decisions for you, and these are inherently personal decisions, right? So there's no easy way to have a default rule that's going to match everybody's desires, right? And so because of that, there's no certainty that anyone else, government, friend, family member, would actually make the same decisions that you would make for yourself. And so again, it's another really key reason why we want to encourage folks to set up estate plans. And then at the highest levels, outside of or in addition to some of these things that you see on the screen today, is a main reason why folks set up estate plans is for asset distribution, right? It's the ability to control where your assets go after your death. And so you can choose to have assets go to benefit family members or loved ones, to support charities, organizations. You can even use estate planning to minimize taxes and actually maximize the benefit to your beneficiaries. So again, lots of reasons why estate planning may be a good fit, and we really encourage every American adult to create an estate plan. So let's talk a little bit about estate planning documents. really what is an estate plan is probably is the key question here. And so as we kind of said before, an estate plan is a set of documents that contains instructions for what should happen if you cannot speak for yourself, whether you're incapacitated or have passed away. And so an estate plan is typically multiple documents. It's not just one document. And these documents in a plan will again will vary person to person and will be tailored to your individual needs. And each document is really designed to do one thing. Your plan might focus on just one or two of these things, or in which case you might just need one or two documents, or your plan might be a little more comprehensive. The most typical plans that we see are, I'm sorry, the most typical documents that we see are wills, trusts, and healthcare documents. And so we're going to dive into each of these over the next few slides. So wills, this is probably what when you hear of estate planning, you typically think of. And so what is a will? So your will, or as it's really called, the last will and testament, is a legal document that controls most of your assets when you die. It goes into effect after your death. So the will only goes into effect after your death. Its purpose is to really handle the fundamental needs for everyone. And so this is why we think that everyone 18 plus should set up an estate plan. It can benefit you. The primary functions of the will are, number one, to determine who will receive your assets after you die. Number two, to nominate guardians for your children and or pets. And number three is to specify your final arrangement. So do you want a traditional funeral or a memorial? Do you want to be buried or cremated, and so on? And so, as I mentioned before, what happens if you don't have an estate plan? Again, it goes to, all of these decisions are made by the government. What ends up happening if you don't have a will in place is that state laws fill in the gap, and they make those decisions for you. And one of the most common misunderstandings of really not having a will is that most people would think, oh, well, maybe I don't need to mark down my wishes because the state would probably make the right decision for me. But that's not always the case. And I like to give one example where, let's say you're married and you have two kids. Certain states may have a state law that says that your assets are then going to be divided 1/3 to each, to your spouse, a third to your child number one, a third to child number two when you die. That may not be how you want it to go. You might want all of your assets to go to your spouse first, right, and then potentially pass on from there. And so again, it's a good example of how state laws may not make the same decision that you would make in your own case. I want to talk a little bit about administering a will. So wills go through, as we talked about, the probate process. The probate process is, on the next slide, is a judicial process to determine the validity of the will and appoint what's called an executor. So if you don't have a will, the court will appoint an administrator to kind of perform those functions of the executor. The executor is basically the manager of your probate process. Their job is to collect the assets, to pay debts, to pay expenses and taxes that are associated with the estate, and to distribute those assets to your beneficiaries. The probate process is typically very undesirable because it's slow. It can take a year and a half to actually go through that process when your family is grieving and you really just want to, everyone wants to move on. So it can take a long time. It's very stressful. Again, this is a time of grief and it's, not fun conversations to have. And it's also very expensive. So in some states, if you have $1 million estate, let's say, that's going to cost just over $50,000 in just statutory fees in certain states. And so going through probate is just undesirable. And while a will help kind of a will help guide the probate process for the judge, there's really only one thing that will allow for you to avoid probate, and that's called the trust. And so we're going to get into a trust next. And then we'll talk a little bit about the differences between a will and trust, because I know it can be a bit confusing. So a trust is a legal document between three parties. There's a settlor, grantor, trustor or a grantor that basically creates the trust and puts the property into it. There's a trustee that holds and manages the assets in the trust. And then there's a beneficiary who the trust is in favor of. And the way it basically works is that the settler creates the trust and gives the assets to the trustee to hold it, and then it goes to the beneficiary, upon passing. There's five primary reasons, purposes of a trust. One, like I mentioned before, is to avoid probate. This is key for many people. Once you've created a trust, anything that you actually put into that trust avoids that entire probate process in its entirety, because the trust in itself is that legal document that will execute your wishes, and assets will just kind of automatically flow and so on without having to go through the probate process. Two is to manage and distribute assets. So a trust gives you a little more control over when and how assets are distributed. So you can add different contingencies to your trust on how your assets are distributed that you can't really do with a will in most cases. Three, which is important, is that a trust applies both during your lifetime as well as after death. So this means a trust can be useful in planning for your incapacity, and can actually ensure there's a seamless transition of control at a time of incapacity. Four is to provide for your family. So a big motivator for folks that create a trust is generally for folks with younger children and or blended families, because of the fact that a trust gives you, again, more control over who will eventually benefit from, or who will basically eventually be the beneficiary of your assets, in a way that, again, a will can't. And so trust can handle that complexity, again, a little better than a will. And then, like, the one other thing I'd note here is that a trust also gives more control over providing for your spouse for his or her lifetime, but then also ensuring that those assets pass to your children after your spouse's death, as opposed to someone else. So again, more protections are there in that case. And then the fifth reason why folks often create a trust is to minimize taxes. There are some ways to kind of minimize your taxes by or potential taxes upon passing in trust creation. I do want to just quickly speak to the role of a trustee. So a trustee, which is that person that kind of who holds and manages the assets. The trustee is basically the CEO of the trust. They're bound by the laws and the terms of the trust. And it's a really critical role because the trustee can work with professionals, they can work with advisors. They're really your quarterback of your estate plan. And so a lot of folks will often choose you really want to think when you're choosing your trustee, you want to make sure it's someone you very much trust, who has the ability to carry out these duties. So a lot of folks will choose their spouse, sometimes children, relatives, sorry, or close friends. There's a few different types of trust. The first is a revocable living trust. That's the most commonly used type of trust. That's the trust that Trust and Will offers through our partnership. It's the thing, again, that most people think of when they think of a trust. A revocable living trust is carried out while you're living. They can be changed really at any time or revoked, and all the assets within it will avoid probate. The second is a testamentary trust. Testamentary trusts are less commonly used. They're created under a will, and they're only created under a will, meaning you can create a will, and then you can also add on a testamentary trust. But there's some challenges. There's some differences between testamentary trust and revocable living trust, because the testamentary trust only goes into effect after death. And those are typically easier to create, but they do often require going through the probate process. And then, depending on the complexity of your estate, there's other types of trusts. There's tax planning trust, there's special needs trust, there's life insurance trust. We're not really going to go into those today. Again, I think the most important thing that we're going to talk to is what we've already spoken to, which is the the revocable living trust. So, talked about wills, talked about trusts. Let's try to simplify this. So, wills and trusts have similarities, but there's also some key differences. they're similar in that they both dispose of assets is kind of the easiest way to think about it. But the key differences as I see them are trusts avoid probate, whereas wills are going to go through your probate process. Trusts give greater control over when and how those assets are distributed, as we've spoken to before. Wills can be easier to set up, and trust can be a little bit more difficult. We make it very easy at trust and will, but generally trusts are a little bit more difficult because there's a little more complexity that goes into that process. Four is that trusts apply during your lifetime. And so, again, trust plan for the incapacity, whereas a will does not. That's only a will only goes into effect after passing. And then the fifth one, which is important, is that a will allow you to is only a will. Can you nominate guardians and specify your final arrangements? Because of that, trusts are usually paired with a will. They're usually a set, and they are with trust and will. You get both when you purchase our trust product. That's because again, the trust can do a lot of things, but it's not going to allow you to nominate your guardianship of your children or pets or specify your final arrangements. A will, and so because of that, a trust is usually paired with a will. So I'm going to dig a little bit deeper into the trust. Like when should you consider a trust? One reason is when you have younger children. So again, more control over when and how assets will go to your children. So with the trust, you can add in triggers. You could say, like, if they turn a certain age or hit a life event like graduation or getting married, you can stretch out the distributions over time, so that that you have a greater level of control there. Complex families, we've kind of talked about that before. But that's a key reason. Third is privacy. So we didn't talk about this, but the probate process is fully public, and so your will become public through the probate process. And so there's a lot of folks that may just want everything to remain private, in which case you can create a trust. And again, trusts don't go through probate. It's just going to execute itself kind of outside the court process. And then for higher asset levels, once you hit, there are certain tax thresholds, estate and income tax minimization. Like there's some tax reasons why folks would set up trusts, whether it's a revocable living trust or some of those other types of trusts that we've kind of spoken to earlier. So we've covered wills and we've covered trusts. Let's talk about the third common set of documents, which are healthcare documents. So healthcare documents include three types. The first is a HIPAA authorization. The second is the advanced care directive, or typically called a living will. And the third is a power of attorney. We'll dig into each of these. So these three documents really cover what happens when you are incapacitated. And so while a will or trust covers what happens to your property when you die, this part of your plan again covers your wishes and finances and care really for you while you're still alive. So your power of attorney on the next slide. Your power of attorney designates someone to make non-medical decisions for you, like financial decisions or business decisions, or really just handling any day-to-day transactions. So it's a really important piece of the estate plan. Your healthcare directive, or otherwise called a living will, specifies your medical preferences in advance and designates someone to actually make other medical decisions for you when you're not able to voice them. And so that's an important thing for incapacitation, as you can imagine. And then the third is the HIPAA authorization. It just ensures that your designated agents and representatives can speak with your medical providers so they can make decisions, consider costs of treatment, and et cetera. So it also ensures that stakeholders in your care have access to your health information and can communicate with providers about medical history and make decisions. It's a piece that's often overlooked, but is really important in our view for properly protecting yourself long term. So who needs an estate plan? I've said this a bit in the beginning, but we believe everyone over 18 should have a plan. There's a variety of reasons why we call them more like triggering events for folks to create an estate plan. One might be joining a webinar on a Wednesday night and learning more about estate planning. But other than that, it's very much about the key triggers that we see are folks getting married, having children or grandchildren or pets, accumulating assets, potentially coming to medical concerns. That could be a big reason. Oftentimes, if your loved one or someone around you passes, you might be thinking about death and what happens if you were to pass. So that's a big triggering event as well. Approaching retirement's a big one. So there's really a variety of ways or reasons to create an estate plan. And as children, as you can see here, as children become adults, they need their own plan, right? Once you're 18, ideally they create their own plan. So as your uh, plan evolved, there was actually a question that I see that's a perfect setup for this slide is once you've created your estate plan, you're not done, right? As you go through life, your plan should evolve just as your life and situation does, right? And so you want to make sure that your wishes are properly reflected as your life changes. So if when your needs change, you may want to consider updating a beneficiary or changing your guardians, or just generally speaking, you might have different preferences as you age. And so there's a variety of common triggers that will trigger you to update a plan, like a birth of someone, a death, change in marital status, retirement. We suggest that folks um, take a look at their plan and review it every 3 to 5 years, just on a regular basis, and make updates as needed. Um, so with that, just a few more slides here is to make it. Oh yeah, so we want to make it a little easy to get started. There is some information that you really do need to get started with the plan, and then there's some information that you may think you need, but you really don't. And so, what do you need to get started with an estate plan? You need your basic information. You can see here names of family members, your date of birth, and so on. You need to have or think throughout the process who you want to nominate as guardians. You want to think about who your trustee is. And then you want to think about, how you want your assets to be distributed. Now, through our tool, we really walk you through this process through Trust and Will to make it very easy, but that's really all you need. On the next slide, you'll see you don't need your social security number. You don't need the actual bank account numbers of all of your accounts. You don't need all your online passwords. You don't need your real estate titles or business paperwork. We make it very easy um, at Trust and Will to actually, still create a plan without all this information. Even if you go to an attorney to create it, you don't need all this specific information. So again, you really could probably get started today. And so with that, I think it's probably a good segue into Trust and Will and our company. So our whole mission is to make estate planning easy. And we do that we've done that by building what we call basically the TurboTax for estate planning is the best way to think about it. And so we can see on the next slide, the experience is fully self-guided. It will take about 20 to 30 minutes to complete your estate plan, the whole thing end to end. We have a support team like Jason and others who are available 6 days a week via live chat or via call as you're going through the process. We offer it in certain states, which we can follow up later, but in certain states we offer attorney support. So if you actually wanted to speak to an attorney, you can do that for an additional fee. And it's a very, very cost-effective way to create an estate plan, especially for the next 2 weeks until October 31st, while we are running a 25% off promotion. So on the next slide, you'll see our cover. What we offer is basically two packages. One is a will-based estate plan, and you can see all the documents, which now you have context of kind of what is included in each of these documents. It includes those four: the last will and testament, the living will, the HIPAA authorization, and the power of attorney. And the pricing you see here is our standard pricing with your credit union. So after this special promotional period in October, it'll go to this 10% discount. Again, next 2 weeks you'll get 25% off. But the pricing here is very affordable, right? Again, like I said, to go through an attorney, it's about $800 on average to create a will. You can get it for 143 through Trust and Will, or less again. And then on the trust-based estate plan, which is the second package, you get everything in the will-based plan, and then it actually also includes the living trust. So on the next slide, we'll just quickly walk through the experience. We'll help guide you towards um, the right product for yourself. So the first step that you'll land on is a bit of a quiz, and depending on the answers that you put in, we will say, a will might be the best fit for you, or a trust might be the best fit for you. You can choose whatever you'd like, but this is often a good way to kind of get started. And again, you can always chat in to our support team or call us, and we can help walk you through the process as well. And then from there, it's a very simple and clear interface. We make it very easy for you to go one question at a time. You start by entering your basic information. Then you can add in your assets. You're looking at, a distribution page here. Progress is saved. So once you've created your account and you start the process, you can pause, you can leave, you can come back in a week and log back in and start where you left off and have conversations. Like, there's no rush. We don't want to rush you. We want you to make sure that you have a very good experience with Trust and Will. And then, as I kind of mentioned, our member support team, our member success team, like Jason, 6 days a week, we have very, very high customer satisfaction score, and we have attorney support that I mentioned before in about 34 states. Can be added for an additional fee of $200. I should add that we do have attorney support in California. And so for $200, if you did, in addition to the fees we talked about before, you're able to connect with a licensed estate planning attorney. So to get started, we have the credit union's created a website, lapfcu.org/trust is the site to go to learn more. And then from there, it actually will take you to Trust and Will. Again, it's typically a 10% discount, but on the last slide, we'll see that you'll get 25% off again from now to October 31st. Look, the goal here is not to convince you to utilize Trust and Will. Truly, the goal here is to educate the group on estate planning in general, and we encourage you to test us out and hope, however you do it, you create an estate plan. So with that, yeah, great. So I can pass it back.
All right. Thank you so much for sharing a lot of great information. As you guys can see, the information is on the screen as far as like accessing Trust and Will and their services. I will like to mention also that the giveaway that we're giving, valued at $600, will be announced tomorrow. So stay tuned for that. And then also don't forget the incentive that they are offering, the 25% off is good from October 16th to 31st in honor of National Estate Planning Week. Now, also, I would like to mention, if you are a member with the Los Angeles Retired Fire and Police Association, that you can get up to $600 in terms of a reimbursement towards an estate planning, towards developing one. So you may want to look at their website for more information regarding that. And I would like to mention that that is not affiliated with LAPFCU or Trust and Will, but if you are a member with them and you are active paying dues, that's something as a benefit for you. So now I think we'd like to turn it over to the questions and answers. I know we've got a fair few in the box.
Yeah. So I'm gonna walk through some of the key questions and answers that were chatted in that I think might be relevant to the group here. First is around updating a will. So someone said, like, I have a trust that needs to be updated as there's been changes to my assets and property and also moving to another state. Can you do this? We actually can. We have something that is called a trust restatement. So you can basically go through the Trust and Will experience and basically restate your existing trust. And again, it only takes 30 minutes and it's going to be way less expensive than going to an attorney to make changes. So if you do have an existing trust and actually want to kind of bring your existing trust, update it and bring it into the trust and will universe, you can do the same thing. The cost will, or you can do that. The cost will be the same as just purchasing a new trust through trust and will. There's a couple of specific questions here. There was one question that said, does the court appoint the executor or can one be indicated within a will? The answer is if you do not have a will when you pass, which is otherwise called dying intestate, the courts will appoint an executor for you. But if you do have a will, you can nominate your own executor. And that's why it's one of the core reasons why folks want to create a will so that you can nominate your own person. There was another question around, yeah, that was actually the same question. Someone asked, will you be able to provide a contact number to discuss further? If you have questions, we very much recommend going to our website and you can either email us at support@trustandwill.com or just go to our website and chat us in, ideally during the during the day, during our working hours. Our hours are listed on the bottom of the website, and we'll be able to answer your questions or call you back in the future. Another question around, is there an annual membership fee or with Trust and Will? And so there is an optional membership fee. So the way that works is that once you create your will or create your trust with Trust and Will, the membership that we offer is free for the first year. And what that membership enables you to do is make unlimited changes to your estate plan. There's a few other bells and whistles to it, but it basically just gives you the ability to make changes to your estate plan. After that, if you choose a will, then you can pay $19 a year, so a very nominal fee to continue to subscribe. Not a month, it's $19 for the full year, and you can subscribe to Trust and Will, and then you can actually make changes for free. If it's a trust, it's at $39 a year to make those changes as well. Most of our customers, which I didn't mention, I probably should have earlier, is like at Trust and Will, we've done over 700,000 estate plans through the country. I believe, the largest digital estate plan provider in the U.S. We partner with all sorts of organizations like you all to bring this in the hands of folks. Like, very trusted, and LAPFCU certainly will vouch for us as well. So just want to make that note. Question, does your trust and will package include durable financial power of attorney as well as durable healthcare power of attorney? Yes, they both it comes with both the financial POA and basically the advanced healthcare directive, which is the durable healthcare POA. Let's see. And then there's another question around the membership. So again, you can make changes for the first year for free, and then you can opt in from there to subscribe and make changes for free make changes if you're a subscriber. I should note, you'll never lose access to your estate plan. So even if you choose not to subscribe through Trust and Will, like, you will have a physical estate plan we send you, but it'll also live digitally within your Trust and Will account. Even if you don't subscribe, you can always see it and download it. You just won't be able to make changes unless you subscribe. Let's see. Can you nominate more than one person as an executor? With a will, you can only name one executor, but you can name backup executors. If you have a trust, you can name multiple successor trustees who can share the role of distributing your assets. So it's a bit different for each of those. Let's see, attorney support. Someone asked how much more is it to add attorney support? It's an additional $200, and it basically gets you unlimited consultations with them, specifically on your estate plan for a year. And so it's a fantastic value, and it can help give peace of mind for folks that are interested in that. Let's see. Good question. If you create an estate plan in California, is it effective when you move to another state? The answer is yes. Once it's signed and notarized, the estate plan will be legally valid in all 50 states. A couple, there's a few questions that are very specific, and I'm not going to mention those, like specific to someone's estate situation. Probably not relevant to everybody. A lot of questions on the 25% off. If you actually go to that site, if we can maybe go to the previous slide again, just so they can see it. Once you go to that site and you hit uh, to go to trustandwill.com, you will actually get the 25% discount will automatically apply. You don't have to put in a promo code or anything, it just automatically happens. So long as you check out and make that purchase again by October 31st. There's a question around probate on our website, which is a very good question. We offer a third, we kind of have a separate line of business around the probate process, which upon passing, that's for folks who are actually going through probate. They have a family member who may have passed and they're responsible for going through probate on their behalf. We have a solution there that is separate from our estate planning solution. You might see that on our site. It's not something that we're going to go into today, but you can certainly learn more on our website for if you are going through the probate process, how we can help you go through that process as well. Good question around, do we need to have the documents witnessed by others or notarized? Your documents will need to be signed and notarized in order to be legally binding. We go as far as we possibly can to help you get your documents notarized. So we, in certain states that have passed laws that enable online notarization of documents, we make it easy so you can actually get it notarized and witnessed online, all digital, end to end. If you don't live in those states or you choose not to do that option, once you receive your physical documents with us, we actually give you directions on how you can get them notarized. Either we, through a partnership we have with a mobile notary service that expands all 50 states, so you can actually have someone come to your home and notarize it, or we'll encourage you to go to a UPS store or bank, or there's a variety of ways to get it notarized, but we really do try to provide as much content as we can to educate folks on getting them notarized. This will be recorded and shared out. This is recorded and this will be shared out, which would hopefully be helpful. Great question. How do we start the process? I think we've talked about that before, where again, just go to the site that we've listed before, and you'll click through to Trust and Will, and you'll be able to start that process from there. A couple more specific ones, membership questions. Yeah, I think those are the main questions that make sense for the group. I don't know, did anything else come to mind, Natalie?
I believe there was a couple of questions submitted to me directly, but I think one of the person put it in the all chat. We have another one here. Can you add $200 attorney fee at a later year if you are a member, or just when you sign up?
Great question. You can you can opt into our attorney service after. It doesn't have to be at the initial purchase, as you call it. You can add that in later.
Okay, great. That's all I have on my end.
And then I'm going to add one more thing because I see some just came in the last minute. So I'm going to try to get to some of these. Is California one that allows online notary services? I don't believe so. And the other thing to note is that the trust, in the states that do allow for online notary, I think there's 7 or 8 of them. It only applies to the will-based product and not the trust. And so there's some complexity there. But yeah, I'm actually not sure about California, so I don't want to give the full answer there. And then there's a question around special needs trust. Is the special needs trust covered on the website? We have educational content on our website around special needs trusts, but that is a different type of trust that our company does not offer today. And we just do a revocable living trust. So I think with that, I'd encourage you to come to our site, check it out. We've got all sorts of educational content in our Learn Center. Feel free to get started, chat with us, ask us questions, and we want you to be comfortable. And we want you to hopefully trust us to create your estate plan.
Okay, and I think that wraps it up for us this evening. Once again, I'll leave this slide up here in case anyone has any questions. For those of you with specific questions, particular to your instances, what we can do is answer them starting tomorrow. We can email you back, and then that way you have more of a one-on-one answer from us. Otherwise, if you wanted to ask those questions at the Trust and Wills website, you can as well. And with that being said, we just want to thank everyone for joining us tonight. And well, like I said, we will mention the winner of the estate planning giveaway tomorrow morning. So thank you and have a good evening.
Thank you all. I appreciate it.